Lyoness, Lyconet and Myworld founder Hubert Freidl and managing directors are personally liable in connection with the insolvency of Myworld International AG. The insolvency and all related information and disclosures are of considerable benefit to us. As things stand at present, a restructuring plan does not appear feasible, as it would require the approval of a majority of creditors. An offered quota of only 20% would be unacceptable in any case, especially since the necessary assets are demonstrably not available. Furthermore, it is certain that the majority of creditors will not approve this plan. As part of the legal review of the economic events surrounding the insolvency of Myworld International AG, a thorough examination of the facts and the legal situation has revealed that several managers and decision makers are facing specific personal liability risks. From the perspective of our lawyers, the situation is as follows. The defendants in the proceedings are Hubert Freidl, founder and de facto decision maker; Dominic Freidl, jointly responsible for international communications and marketing; Marko Sedovnik, member of the management board of Myworld International AG; Monica Mararova, authorised signatory; and Mario Capoon, sales manager and key figure in the marketing department. Defendants number 3, Sedovnik, and 4, Mararova, in their capacity as managing director and authorised signatory, were directly obliged to file for insolvency immediately upon the occurrence of insolvency or over-indebtedness in accordance with section 69I(0) and to take all measures to avoid damage to creditors. The continuation of business activities despite the documented economic crisis, the active promotion and distribution of shopping point packs, and the lack of transparency towards creditors and investors constitute a gross breach of their duties as officers. This gives rise to a personal claim for damages pursuant to section 84(3) AKTG. Defendants 1 to 5 jointly contributed to the company being presented to the outside world as economically stable despite its actual insolvency. At the same time, funds continued to be collected from consumers and marketers. This intentional misrepresentation, combined with the continuation of an economically unstable business model, constitutes intentional immoral damage within the meaning of section 1295 ABGB. Although the tax office had already issued a security order against the company on the 30th of December 2022, thereby seizing liens on key assets including the trademark, real estate and a business jet, the company presented itself only 6 months later in July of 2023 at the Lyconet event in Girls Incursion. The company nevertheless presented itself as a shining global player and pretended to be planning an IPO. Marketers were deliberately not informed about the acute risk of insolvency, but were encouraged to make further investments through PR measures. This intentional misrepresentation constitutes personal liability for deception. On behalf of our clients, in addition to the measures already initiated, we are preparing to file a claim with the competent regional court with the aim of holding the defendants jointly and severally liable for the damage incurred and establishing their continuing liability for future damages. At the same time, we will seek to join the proceedings on behalf of our existing clients in accordance with section 187 of the German Code of Civil Procedure in order to conduct the proceedings efficiently and uniformly. We are in contact with all relevant authorities in the various insolvency proceedings and will keep our clients informed of future developments.